Hi, this is Professor Chad McGuire, and welcome to this second video focusing on the remedies under NEPA, the National Environmental Policy Act. This follows our introduction and overview of NEPA as a major federal law and overarching environmental policy related to the actions taken, many actions taken that trigger government action in the United States, that we, under NEPA, consider the environmental impacts or potential environmental impacts and consequences of our actions before we actually engage in any major significant activity in the United States. So here we're focused on the remedies that are available under NEPA, and the prior video, which will be linked at the end of this video at the very least, discusses the introduction to NEPA as a general concept and topic, and then an overview of how NEPA works substantively as a statute. By way of introduction for remedies, first, we can start out by saying that if NEPA does not require a specific outcome, which we've previously established, NEPA is a process-orientated statute. It requires you to think about environmental consequences or environmental impacts of potential activities, but it doesn't require you necessarily to do anything once you've engaged in that process of thinking about. So you can find, for example, that, hey, we want to start this project, but before we engage in this project, build a new highway, build a new building, do something else, start in, lease a section of public land for development, for oil and natural gas, for example, whatever it might be. And before we engage in any of those activities, we think about the environmental consequences. And we might find in that process of thinking about environmental consequences that, first off, there aren't any serious environmental consequences that we can foresee. And as long as we've engaged in that process legitimately, and we've done that evaluation honestly and openly as a government or an entity that's connected to government, then NEPA has been met. But even if we find during that process that, yes, in fact, it's very likely that our activities will result in environmental consequences, and those environmental consequences are serious, as long as we've looked at that, and again, under NEPA's requirements, as long as we've looked at alternatives to that action, alternatives to can we change the way in which we want to do this project to limit environmental consequences? Can we not do the project? Can we, put the project somewhere else where there's less environmental impact? Say there's a biodiversity hotspot where we want to do the project, but a mile away is an alternative site. And if we do it there, there aren't the ecosystem consequences to the environment because it's not a biodiversity hotspot, just something like that, just to give you an idea if we're thinking about this. So as long as we've engaged in that process, including an alternatives analysis, and as long as we've taken a hard look at all of those activities, including what they call the no action, and again, this is under the substantive portion of NEPA, as long as we've considered both the alternatives, including a no action alternative, like doing nothing, choosing not to do the project, as long as we've done that, we can still move forward, even if there are significant environmental consequences. NEPA does not require us to change our behavior necessarily. There may be other aspects that force us to change our behavior pattern, but NEPA itself does not require a specific outcome. So just in terms of bringing that back to the forefront of our thinking, if NEPA does not require that specific outcome, but rather just a process, then what are the remedies available for failing to follow a process? That's what we're focused on here. So if you violate NEPA's process orientation, the procedures of NEPA, what are the remedies available to you? Some questions that we can consider include, what precisely are the procedures that need to be followed? So first of all, if NEPA is procedural in nature, what are those procedures that we need to follow? What is the evidence that proves those procedures haven't been followed, aka a NEPA violation? What evidence exists and can be used to seek some sort of remedy, judicial remedy? If I was to go to court, how do I go to court? Or how would anyone who has standing go to court to identify that, hey, the procedures that are mandated under NEPA weren't followed, and here's the evidence to show that those procedures weren't followed? And then for the court's purposes, what standard of proof is applied? So in other words, here's the procedures I think haven't been followed. Here's the evidence I think that shows that this, in this. Now, does this evidence meet some level, some standard of proof sufficient to show a procedural violation of NEPA? So these are the kinds of questions when we think about remedies under NEPA that we can apply. And then, of course, finally, after the standard proof, what remedies are available? So once the court, if the court was to determine, yep, we understand the standard of proof, the evidence is sufficient evidence to show there's been a procedural violation. So what? So if all of those things have occurred, then what happens? What remedies are available for a NEPA violation? And outside of those questions to consider, what about exceptions for violations? We can also think about this in terms of remedies. So even if we've proven all of those things, there has been a violation of NEPA. We've met the standard of proof, and there is a potential remedy. Question is, are there exceptions? And sometimes, as you'll find in most laws, certainly in NEPA and other environmental laws, there are exceptions, even when the government has not followed the tenets of NEPA, national security, economic impacts, etc. And right there, I just want to hold for a moment and, and we can consider this notion of, for example, economic impacts and even national security. What's implicit there? If we go all the way back, certainly to our overview of NEPA, but even before that, to our overview and introduction to environmental law concepts, as we started the course, we can bring forward again, what is the environment and how do we relate to that? How do we define the environment for purposes of environmental law in the United States and generally speaking? And therefore, what are we protecting? And we talked about the idea of the cartoon economist versus cartoon ecologist, the idea of an economist perspective or point of view, where humans are the center of however we want to define the environment, human well-being, for example, and human activities at the center. Whereas maybe for the ecologist, humans aren't at the center of the consideration, that the environment for the environment's sake, where the environment has sort of a natural definition that does not include an operational connection to humans. What this suggests under NEPA, the idea that there are exceptions to NEPA. So you have violated the consideration of environmental consequences. That's what NEPA requires, and you have not followed that process. However, even if you have not followed that process, you're given, a way out. And the way out by national security, for example, says that there is an interest that outweighs those environmental considerations to consider the environment under NEPA. There are other interests, and certainly economic impacts definitely suggest that there are other interests, other considerations. And those other considerations, many would argue, puts humans at the center or forefront of the consideration. So these exceptions are probably championed by our cartoon economist arguments or points of view regarding what the environment is, how to define the environment, rather than maybe a more ecologist. So we said in the overview and introduction materials to NEPA that NEPA, by its very definition, places the environment into so many, because of how expansive it is, what it's been determined to apply to so many different types of government actions, even indirect government actions NEPA applies to. And as a result of that, we said that, wow, that really brings in, because NEPA is really about thinking about the environment in a very expansive way. Even if it thinks about humans at the center of it, it includes all of those important sort of ecological components of the environment. It's really what's brought into the conversation in a lot of the NEPA evaluation. So we said NEPA really brings in that ecologist point of view, and it does, without a doubt, as an overarching policy statement. However, when the rubber hits the road, and we think about NEPA in terms of its ability to actually enforce specific types of decisions, or where it prioritizes the environment and maybe a natural definition of environment over other human interests, we can say that these exceptions suggest that those human interests might outweigh those environmental priorities, national security, economic impacts. And we'll talk about that quickly. In terms of the assessment process, so we can think about remedies. First of all, if there's a remedy, we have to assess where something went wrong in NEPA. And there are two parts to this, really. So we talked about this in the introduction and overview of NEPA, that government discretion is key. So NEPA applies to scenarios where government has the ability to say yes or no, make a decision. And what we mean by that is there's a lot of decisions that government has to make that are non-discretionary in nature. And that means government's doing something that they've been told to do. So the executive branch, for example, is simply implementing congressional mandates. So there's a law that Congress has passed that has a mandate. It says you must do this thing. Well, in those instances, when it says you must do and there are no exceptions, there's no gray area, there's no room for decision making, that is considered non-discretionary. It's a clear example of non-discretionary. And in those cases, if the government is doing something they must do, then there can be no judicial review. Government has simply no choice. It is mandated by statute to act in a specific manner. And in those cases, no matter what happens, if government's simply doing something it must do, then NEPA really doesn't apply, because there's no opportunity to consider NEPA's alternatives, to consider, the effects on the environment relative to alternatives, relative to no action. There's no discretion for government. Government simply has to do it. So we need to see in the assessment process, number one, first off, whether or not we have a potential remedy under NEPA. The first question is, well, does government have discretion in their action or activity? And if they don't have any discretion, if it's non-discretionary, then simply there is no potential remedy under NEPA. If there's discretion, then government has a choice to engage in the activity, alter the activity, or not engage in the activity. It can do the things that NEPA really says government should think about. Again, NEPA doesn't mandate a certain outcome, but it mandates a process of thinking, of choice, a process of coming up with, well, could we do things differently? And if we did, what would it look like? And what would, the relative costs and benefits, what would it mean to do something different? What would the effects be? How would it benefit these environmental consequences we've identified, these environmental assets, environmental issues? Again, with wide discretion on what environment means. Again, with humans, we've talked about that ad nauseum, but it's always difficult because the term environment is really, it's somewhat normative. So it's really important to define, because contextually, it can change. Contextually, you can say, well, I'm focusing on this very narrow definition of environment as I look at potential environmental consequences. And of course, others would say, no, that's silly. That's incredibly narrow. You need to have a wider definition. There are all of these things over here that are important for the environment. We've talked about this. And so you can look at those introduction to environment, what is the environment, and certainly even the introduction overview of NEPA videos to get a stronger sense, if you're just watching this video without those as context, to help you understand this wide-ranging sort of normative definition of environment. But anyway, so if government has some choice, then that really matters. That is really the first part when we're thinking about remedies under NEPA, if they're available. So that's number one, government discretion. Number two is there a potential for environmental impacts? If there is a potential for environmental impacts and government has discretion, then judicial rules and remedies are possible. So number one, is there discretion? Yes. And then are there potential for environmental impacts in this action? In other words, and we'll show what that means in this process. And what it means is, if we move to this slide, this you'll remember, if you've seen the introduction overview of NEPA, of the National Environmental Policy Act, you'll remember this sort of process that we lay out here. So what we mean by, is there potential for environmental impacts? Well, that's the whole sort of NEPA process laid out here. First of all, NEPA applies to major federal actions that may significantly affect the environment. All those major federal significant environment, they have all, again, in the overview of NEPA, we define those. They've been defined operationally, both by executive action and by judicial review, what those terms mean contextually. So the point is, that's what NEPA applies to. And then if the answer is yes, then there's an engagement of an initial environmental review. It's called an environmental assessment. If there's a no, then there's a FONSI, or a finding of no significant impact. But if we're at the yes, there's the potential for it, and then does this initial environmental assessment show federal action that will likely have a significant impact on the environment? So if we move forward with this project, is it likely to have a significant impact? If this preliminary review, which is a lot less intense, a lot cheaper, if we want to talk about it in financial terms, it's a cheaper sort of superficial process. But if that EA process shows there's a likelihood, then you must do a much more in-depth environmental impact statement. If the EA shows no, there look like there were some environmental issues, but there's really no federal actions likely to have very little to no significant impact on that, then there is a finding of no significant impact, and we're done. But if we're at this EIS, then does the EIS, this is the process. So if we have an EA that then leads to an EIS, and the EIS says that there is significant potential, all of those decisions really are the trigger here when we say, and the previous, when we say that if there is potential for environmental impacts, that's where we determine the potential. And again, for our purposes, we must remember that if government says no, 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 any of these no's, all of this is made public. The process before they come to these decisions and finalizing and moving forward with the project, all of these no's require, and all of the yeses as well, require transparency, public notice and comment in association with the Administrative Procedures Act at the federal level, the APA, which is an administrative law principle that requires a lot of sort of sunshine, light on government actions. And that notice and comment period means that the public gets notice of these things. Here's our determination. Here's how we came to it. Here's the evidence that we have to support it. Tell us what you think. Do you have all have you studied that? Are you a group of scientists or, ecologists, and you've reviewed this area, or, the friends of, such and such area where we propose this activity? Do you know of things that we haven't identified? You have the opportunity to put into the record any information during that comment period. And then we have to then incorporate that information into our decision-making process. I just want to make that clear that the government just doesn't say no to any of these things out of expediency and without any other input and without transparency. They say no with a lot of public input and a lot of public transparency, especially for large projects that are controversial in nature. So those no's are always checked. But the point is, if there's the potential through that entire process to show clearly for environmental impacts, then there's the opportunity, as long as there's discretion, there's the opportunity for NEPA remedies to apply. And I think we have that. So let's start off with two ways in which there's a trigger for remedies. The first way in which there can be a trigger when there is government discretion and where there's the potential for environmental impacts. And the first way is government decision that's not supported by the record. This is important. So basically what's happening here is we have our decision-making process over here on the right, one we just went over, and the government's saying no, mostly. And when they say yes, then, there's generally not an issue. But most of the time when the government falls into a no, any of these no's here, then there's the question of the government decision not being supported, that the no was not supported by the record. And for our purposes, there's those three main questions. Is there major federal action that may significantly affect the environment? The government can say no, and that no, again, through that public notice and comment, can be shown to not be supported by the record. And then does the environmental assessment, assuming they do one, show a federal action that will likely have a significant impact on the environment? They say no, but there's evidence to support, yes, there is significant impact as defined by case law, executive opinion, so on and so forth. Then, again, there's an opportunity for remedy under NEPA for the courts to force government to do something they haven't done. And then does the EIS show the federal action will significantly impact the environment down here? And if there's a no, but again, there's evidence and in the record to support it, that there's a yes, then the alternatives analysis. There's in any of these three questions is where the government decision, however the government decides, mostly the no's, is not supported by the record. So the judicial review focuses on those three main questions to the right, where we have arrows there. And the query is government decision supported by available evidence at each major inquiry? So available evidence, key here. It's not just the evidence that the record the government's established itself through its preliminary process. As I noted before, it also includes that public notice and comment period where more information, legitimate scientific reports on the area, studies that have been done, so on and so forth, observations, lay observations, people, that all of that information now becomes part of the record. Therefore, it is quote unquote unavailable evidence, and government has to incorporate through APA notice and comment periods during each part of this process, that information into its available evidence. So that's key. The query that the that the courts would use in determining whether or not a potential NEPA violation by the government decision not being supported by record has all of the available evidence and includes not just what the government's done, but additional available evidence, existing reports that government didn't review, pre-existing reports, that kind of thing, studies that have been done, all of it. And so the available evidence is based on the administrative record, as I just mentioned, government review studies, as well as public comments and evidence studies, et cetera, and that notice and comment process. That's really important to understand. It's holistic in its approach in terms of what the available evidence, it's that administrative record, what's been put into the record. And where the evidence supports environmental harm, government or public, but government finds a finding of no, the finding of no, then the basis for court to enforce additional environmental analysis. What the court does is it says you need to continue with this NEPA process, NEPA being a process statute, not an outcome statute, right? I mean, we can have a debate about whether, process equals outcome, and it certainly does. If the outcome is to do a further environmental analysis as part of the process, that is an outcome. That further environmental analysis, some would argue, is an outcome, sure. But as a procedural statute, it really forces this process or procedure to occur where within the procedure, certainly doing things are in and of themselves the requirement of doing that thing. An EA, do it if you haven't done it. An EIS, do it if you haven't done it, if the evidence supports it. One of the things I want to point out quickly here is that when we talk about the administrative record, government review studies, of course, the government sometimes doesn't follow the information it provides itself. It makes a decision not based on the evidence that it creates and establishes supports a significant impact, and yet they find for a FONSI. That does happen. Most of the time, though, it's additional evidence that the government hasn't produced, and it's those public comments and evidence studies, et cetera. What this suggests is how important the public's role is in ensuring that the government is following, it's all of the information that's available. So public interaction, it's so important in a democracy, and certainly in these procedures where government's taking actions, and yet those actions are supposed to be checked by all of the available good information. Well, that requires participation. It requires individuals and groups to be active, to see what the government's doing, to read and review that administrative record when there is a public notice and comment on it. Hey, we're going to propose this project, and we've done these studies, and here's the preliminary evidence, and so on and so forth. So we can see the importance when we're talking about environmental well-being, certainly under NEPA, but also under other environmental statutes, federal environmental laws, and also at the state level and even local level, is the notion of an active public, an active and participating public, incredibly important. So that, again, as we always look at these things through a policy lens, we want to understand that NEPA in its functioning and many other major federal environmental laws in the United States really require active public participation in order for that check and balance to really work very well. So government decision not supported by the record, we can see how that sort of plays out here. The other way in which NEPA can provide remedies is a failure to consider alternatives. So we have government decisions isn't supported by the record, basically getting to a FONSI when they should be doing a deeper analysis of environmental impacts, when the evidence supports something other than a finding of no significant impact. And the other is, in the process of engaging in that environmental assessment or environmental impact statement, those deep environmental reviews, a failure to consider alternatives, particularly at the environmental impact statements, the EIS stage, the failure to consider the alternatives analysis, basically, which NEPA requires. So what we mean there is that in our overarching sort of review here, we're focused really on the environmental impact statement stage. This is where our focus is. So when an EIS is required, assuming that we get to the EIS, the EA shows a federal action that will likely have a significant impact on the environment. When that EIS is required, we must consider the alternatives, including the no action alternative, which again is described in the introduction overview of the NEPA materials, which means not only do we consider those alternatives, like I said at the start of this video lecture, can we move it? Can we, limit its size, its scope, that kind of thing, but also, hey, can we just not do it? Doesn't mean that NEPA requires you not to do it. NEPA doesn't. It may force you, from public opinion standpoint, not to do the project or abandon the project, or some other environmental law might force you to not do the project. But NEPA, and what I mean by that, for example, is say the NEPA process shows that there's critical habitat where you want to build this for an endangered species. Well, we have the Endangered Species Act in the United States. NEPA might not force you, when you've identified that critical habitat and done your full environmental analysis, it might not force you not to do the project, but the Endangered Species Act may very well say, hey, that critical habitat, you cannot disturb it as a matter of the Endangered Species Act, a different federal statute. So that's what I mean when I say NEPA might not force you to a conclusion, but another environmental law, for example, could force you to that conclusion of no action. Not going to do it. Judicial review is available here when government fails to consider all reasonable alternatives. What does reasonable mean? For NEPA analysis, it means feasible, has logistic, economic, and impact aspects. So again, this is one of those sort of, we talked about, hey, what's major? What's a major federal action in our overview of NEPA? What's significant effect on the environment? How are these terms operationally defined? Because they're ambiguous. I don't know what major is. I mean, is there a common sense major? Is there a line drawn between major and minor, right? And we talked about how they're context specific. Major, building a high rise in New York City might not be major because there's so many other high rises. Building that in a small town, yeah, if it's the only high rise, that's probably a major action. For example, just that context nature. So here reasonable is feasible, which again, ambiguous, but it has logistic, economic, and impact aspects, these sort of like, these sort of conditional aspects that are put into context. So it's really context, not entirely context dependent, but it has a lot of contextualization to determine what is reasonable under NEPA. But anyway, failure to consider all reasonable alternatives is the general sort of, when we say failure to consider alternatives. Additional reasonable alternative that we can, it's not just all of the alternatives, move it, reduce its size, scope, but it's also the no action alternative must be considered. And so we have that here as, under the EIS, for example, then must consider alternatives, including the no action alternative. That's what we mean by this here. And, so when you think of the no action or reasonable alternative, right? One of the ways to contextualize reasonable here is I have in the materials, for those that have access to the materials taking the course, the idea of the dam example, a goal versus harm. So the idea is that if I want to build a dam and use it primarily for hydroelectric power generation, we can look at the dam and we can say, well, what's the goal of the dam, right? The goal is electricity generation. That's really the goal. And then we can say, but if we build the dam, it's going to have a huge impact on all of this environmental, all of this entire ecosystem, this entire watershed is going to be disrupted significantly. And like I said, part of that watershed, for example, changing, when you make a dam, you're usually going to create sort of a lake at the top of the dam, where the water is running down. You're going to, flood a section, and you're going to diminish, for the most part, the flow of water below the dam. And I say below the dam because water naturally moves in, a downhill progression. So however that looks, so that watershed is going to be affected. And if that watershed contains important habitat, critical habitat for species, that kind of thing, you can look at that and try to measure the harm of the environment based on your definition of environment, and an expansive definition that includes not just human-centered, but also, other things. And total valuation is the thing that we've used, that we've already gone over, as a sort of way of thinking about a wider view of environment, the ecologist's view of the environment. So we can look at the dam example and say, well, what's the goal of the dam? Power generation. But it has a lot of harm. Maybe it doesn't. Maybe a dam in a different place doesn't have a lot of potential harm, right? But we can do this kind of measuring where we can say, what's the goal? What's it intended to do? And what is the harm? And we can try to contrast those. And then when we think about what's a reasonable alternative, well, geez, if it's really easy to create a non-hydroelectric, power generator that doesn't have nearly the amount of harm. So we can cite over here, a solar array or a wind or even a natural gas or even a coal burning, power generation utility, right? And we can do that on the land. It's not going to affect the watershed in the same way, far from it. It's not going to have the same harm effects, right, in terms of the environment, but we can still achieve the same goal, generating electricity. That would be, so when we think about reasonable alternatives, those are all reasonable alternatives, not because they're similar to a dam, damming water, but because they're similar to the goal. What are you trying to do? What's the point? Are you trying to move people from A to B, build a highway, that kind of thing? Are you trying to generate electricity? So we look at the goal often, and we think about reasonable alternatives. They're in relationship to the goal versus the harm that the specific example, the dam, to achieve the goal of generating electricity. So we look at it relative to that. So that's what we mean by reasonable alternatives, no action alternative. In terms of the standard remedy that NEPA applies, the standard remedy is an injunction, otherwise known as equitable relief. So it's not, money damages. You want to do something, but you fail to consider the environmental consequences. So pay somebody a lot of monetary damages. That's not what it is. It's an injunction. And people that understand, basic tenets of the law understand equitable remedies, and injunction being a standard equitable remedy. It's just an order that the court has the power to issue and enforce, and it tells a party to do something rather than, for instance, to pay monetary damages. So do something, continue with your environmental analysis, or stop moving forward with that project because you haven't fully complied with NEPA's procedural requirements. You haven't taken that deep look, including the no action, EIS, you just haven't done enough. So you have to go and do more. So there's a NEPA injunction. Now we understand what that standard remedy injunction is. There's a NEPA injunction generally when government has failed to support their decision-making process. The government hasn't moved the EEA, EIS, FONSI, the evidence contained in the record, right? From the evidence contained in the record. So there's just not enough support for it, as we said, and or has failed to adequately engage in the alternatives analysis of required under NEPA. So when they fail under those two categories that we've already described, in some way, some procedural way, they fail to do everything that NEPA requires, then an injunction is available by the courts. And the types of injunctions, there's generally two. There's a complete injunction, which halts all activity until compliance. You can't do anything, you can't do any more, even if it's just engineering work. I'm not talking about physically doing anything, even just planning. No more planning, no more anything. That's a complete injunction, halts all activity relative to the project. Until compliance with NEPA. And then a preliminary injunction is you halt activity until more evidence is presented. And then you can even have, by the way, I say there's generally two, but there's also a partial. You can enjoin certain activities while allowing others pending further review of evidence. There are many different types of ways in which injunctions can be used and utilized in order to ensure that, again, balancing. Courts are always balancing the interests of the parties, balancing the compliance with NEPA in this case to ensure compliance without unduly burdening the government in its, desires to enhance the public good in some way through whatever project that's going on, whatever potential project. And again, we also said that there are these national security exemptions. And those national security exemptions are really important because they weigh environmental against important government interests. So what they do is they then say, well, there's this really important reason, energy independence, for example, that we need to move forward if it's, let's say, the dam, for example. We really need to move forward with creating more domestic energy. And, because we have to source, this isn't true in the United States necessarily, especially now, we have to source our oil from, it's a world market, but we have to, we don't make enough oil here. We don't generate enough oil to supply our own needs, even though it's a world market. We do. We have more than enough natural gas. We certainly do. Coal, we really, really do. So the idea is that under maybe energy generation isn't the best example, but you can think of a situation where the government wants to do something and they're saying, yeah, we haven't, fully considered, or even if we really can't fully consider or fully appreciate the environmental consequences because this is something just so important to do and we need to move forward and do it anyway. It's almost as if national security, for example, becomes the basis upon which government establishes the equivalent of a non-discretionary. They say, look, even though we have a choice, when it's national security, we really don't have a choice. So we're taking something that looks discretionary, and because of national security, it becomes non-discretionary in its nature. So that's kind of the final exemption. In terms of final thoughts on this, in terms of remedies, NEPA is procedural. It requires a process, but not a conclusion or outcome. That is really important to remember. It's just procedural in nature, so we'll always remember that. And the remedy for NEPA is an injunction, which is an equitable remedy. Okay, so that's something that doesn't require money damages, that sort of thing, and we should know this and understand this. And exceptions exist for other interests, like national security, weighed against the environment. And what that means is that exceptions suggest benefit cost analysis. So that suggests that we're really moving with these exceptions, at least, and taking NEPA, which we've said already, which is a highly sort of environment-based, and bringing in even that ecologist point of view into the decision-making process of government by having government think about environmental consequences before government engages in major actions. But at the far end of NEPA, these exceptions suggest that the economist perspective really starts encroaching in at the end, and we should think about that. So that's really important because overall, we can see NEPA as a really important overarching policy mechanism for environmental protection, or at the very least, environmental consideration. Maybe that's the better way to say it. NEPA is really important to bring environmental considerations into our thought process as a nation, when we engage in major federal actions at the national level. NEPA forces in the environment as a consideration. It doesn't demand a particular outcome in and of itself. But in so doing, as I said before in the other overview, NEPA brings, from a policy standpoint, that environmental consideration front and center when we think about large-scale issues, and that's really important. So that's it for our remedies. So now we have both our introduction and overview, and in this video, the remedies of NEPA. Now that we've discussed NEPA, we can start moving into some specific environmental statutes, and I think our next stop is probably pollution. That was a lot of fun, and I hope you enjoyed it. Thank you.